2024. So would you move the bill, and then we'll move the amendments?
Thank you, Mr. Chairman. I move House Bill 2724 receive a due pass recommendation.
Let's do that more appropriately.
Just by way of background, homeowner associations are essentially the truest form of democracy that we have in the country today. Wins. Now, in a homeowner association, the reason I say it's the truest form of democracy is because most amendments to the CC&Rs require a majority. They say, what does the majority want? And whatever the majority wants, that's what they get. And if there's enough support to amend the documents, then you go out and you garner the support and you amend your documents. If you're opposed to what boards are doing, you go out and through the proper process and through the proper channels, you remove the board members and you elect new board members and you change the process that way. What is happening and what this bill does, it essentially takes situations and it's an attempt by the minority to usurp the control when they can't lawfully do so under their documents. And so now, since this small minority can't get the support of their community, they go out and hopefully they try to get the support of you as their legislators. And the problem is that you as the legislators don't have the specific backgrounds of the facts applicable to each of these cases. So it's difficult for you to make broad sweeping legislation when really some of these are anecdotal. And they're designed solely to deal with, it talks about allowing homeowners to go before an administrative body or a judicial body, notwithstanding anything the documents say about review and standard of review, but allowing this other body to make decisions. In Arizona, we have something that's referred to as the business judgment rule. Any corporation, if they make a rule, if they make a decision that is reasonable based on the circumstances of that community or of that individual corporation, those decisions will be upheld. Well, this can arguably amend what's referred to as the business judgment rule throughout Arizona. And I see you look at your watch. I can continue to go on. Again, real estate is unique. There's a provision here that talks about uniformly enforcing the documents. Well, what is uniformly enforcing? When the declarant is in control, the declarant has an objective. It's to sell units. It's to sell homes. And they may have a different interpretation of what is enforceable and what is required to be enforced than a homeowner board that takes control. Other parts that may essentially be interpreted as interfering with contracts. It says that this chapter shall not be modified by agreement or otherwise waived, meaning an association and a homeowner or an association and someone else cannot enter into an agreement to modify certain provisions. They're bound. Both parties are bound. Again, if the effect is to give homeowners rights, I believe that's taking away rights of the homeowner to enter into a contract.
Thank you, Mr. Chairman, members of the committee. I am Scott Potter. I'm an attorney in East Mesa, and like Mr. Morgan, I often deal with issues regarding homeowners associations. I'm a colleague of James Tanner's, who Mr. Morgan referenced, and therefore I find myself oftentimes on the opposite side of the issue from Mr. Morgan. Although I appreciate his comments, I disagree with his characterization of what this bill actually does. Mr. Morgan made it a point to emphasize that this is a very pure democratic form of government, the HOAs. But oftentimes, as I'm dealing in this area of law, the argument is very different from the association lawyers. This is actually a strict contractual arrangement. And the idea that Mr. Morgan has put forward, that this is democratic and somehow opposing this bill protects homeowners' rights, is incorrect. What this bill does is it makes sure that the contractual provisions that homeowners have agreed to are maintained. If you will, it allows a grandfathering of rights, so that when I, as a homeowner, enter into an association, I can be sure that what I agreed to at the time I purchased my house is my agreement as we move forward. Now, what this bill does not do, it does not limit the association from being able to make amendments. It simply states that those things that are expressed in the declaration and are expressly provided for already are the provisions that I can rely upon moving into the future. RS 33-1818, and all it says is that the rules made by the association have to conform to the CC&Rs, and you can only make rules if your CC&Rs say you can. So again, it's supporting the contractual expectations of the homeowner. It doesn't limit the association from being able to make rules and regulations, where 1819, which is included in this bill to codify the restatement third of property servitudes. Recent trend in Arizona through the courts, the Supreme Court adopted in Powell v. Washburn the view that Arizona courts will follow the restatement, and the Appellate Court Division 1 affirmed that decision in Tierra Ranchos v. Kitchikov, that the restatements give great insight into the way that CC&Rs and declarations should be interpreted. The sections that I referred to just make sure that any amendments that will contradict current provisions of a declaration have to be agreed to by those who would experience an adverse effect, and that any amendment that is unequal in its impact must also be agreed to by those people who feel the unequal impact. And it just goes to support the fact that when I come into an agreement, I should be able to have a reasonable expectation that agreement stays in force how we agreed to it, and the people can't go changing the rules on me in the middle of it without me agreeing to a change of the rules. This is a basic contract principle. As I said, this is the law around homeowners association is not a democratic or a majority rule. If we break it down to that, then we ignore the fact that this is based completely on the expectations that we agree to when we enter into the contract.
My point isn't so much the guns. It's the principle of what we did a week ago, saying that if you have signed a contract stating these are your rights, that what you guys are proposing is no one can take those from you at that point. That's what you're signed into. You're grandfathered into that. Is that correct?
Mr. Potter.
Thank you, Chairman. Mr. Wires. Yes and no. In all contracts, there is a possibility of modifications after the fact. Normally, in contract law, and we have to get into it because it is a contract issue, to make amendments to a contract, you're required to provide additional consideration. If you're going to change the agreement, I want $500 more, something along that line. This doesn't eliminate the ability of an association to change the provisions of the contract. It just says that those express provisions which I've relied upon can't be changed unless I agree to them as well. So as an example, if my association had a provision that allowed me to build a shed, I built my shed in 2000. They wanted to change the declaration in 2004 to get rid of sheds. Does that mean that anyone in the association that has a shed needs to rip it down? What it means is if I agree to it, then I have to rip my shed down. If I don't agree to it, then it stands to reason I built my shed with